All right, so let's go ahead and get it started. Jerry, this was the class I really was excited to teach once I came up with the idea. And it's essentially things that should be in the contract but aren't, and things that aren't in the contract but should be. Or no, that's the same thing said different ways. Things that should be in the contract but aren't, things that shouldn't be in the contract but are. Does that make sense? You see any of that, Jerry?
Occasionally, but we try not to have agents practice law without some advice. So,
yeah, and that's a fine line. I mean, what I like to see is I want to see that I'm empowering agents to use the forms to the best of their ability, but they do need some guidance. I mean, it's a teamwork thing. And so it's very easy to go across the line from filling out a form to actually preparing something that requires a lawyer to do. And I think if you partner with us, we can kind of get you there together. You have an amendment, for example, you're trying to change the closing date. Well, the forms are there. They're pre-populated for changing a closing date. But if you also need to give a credit, lean into us. Let us help you with the language. And typically, less is more, right, Dad? The old, that's kind of the hardest thing as an attorney or as a realtor is to write correctly without overdoing it. Because it seems like a lot of lawyers are probably overdoing it, right?
You want it to look simple, but it really isn't. You want it to be comprehensive enough to cover your seller, your buyer. And that's really hard, taking a lengthy contingency and making it look inoffensive, minimal.
I always try and point out, reading any particular sentence in a contract is actually pretty straightforward. They're not written overly complex. The complexity comes when you're trying to compare line 313 to line 478 and how those interplay, and then the addenda or riders that go with it. I think that's where the complexity can come up for sure. So let me present my screen here. Well, I don't know how to do it. Hopefully I'm presenting. Can anyone see this whiteboard that I have here?
I can see it.
All right, good. All right, let's see if I can. Okay, so we're piggybacking a little bit on an article that we sent out last weekend. And the article talks about things that I typically see in a contract that I really don't want to see. I think if you put too much in there, then you risk maybe canceling two things out and not having anything. You risk confusing people, and that's kind of the opposite of what we're trying to accomplish. And so the first thing that we get a lot of times is, hey, I know that my seller is foreign and they're probably subject to FIRPTA. What language do I need to add into the contract? Separately, my buyer is using 1031 for this transaction. What language do I need to add into the contract to accommodate that? And maybe a seller is using 1031 money for it. And honestly, you don't have to put anything in it. The only thing we look to is the contract assignable in the event that the 1031 company requires a different company name or a different entity conveying title. Yeah, Dad, do you have kind of like a 2-minute or 1-minute summary on kind of how that 1031 money works and why you might need to assign the contract to a different entity?
Well, if they're doing a reverse exchange where they're buying their replacement property first, they tend to want to take title in an LLC where the buyer is going to front the money for the purchase, a loan to the LLC, and then when he sells whatever it is he's selling, he'll use that money to pay off the loan and get the property distributed from the LLC to him personally. So
yeah, reverse 1031s are crazy. We probably do a handful a year, not too many, but what is it? It allows you to buy the replacement property before you've sold the one that you're replacing it with.
We're trying to sell something up in New York again, and the market isn't moving fast enough, and you ran across the deal of a lifetime in Naples, and you don't want to lose the deal in Naples, and you have enough money of your own that you can pay for it, but you really want to make it an exchange.
Yeah.
So there's a way to do it where you can use your own money and lend it to an LLC, that's ostensibly owned by a qualified intermediary. That's what the code section calls for. You lend the money, it acquires title, and then the same old 1031 rules kick in. The buyer has 45 days to identify what he's selling in New York, and 6 months to close. And then once he closes, he takes that money and pays off the loan.
Yeah. So and we're not supposed to talk too much about 1031s, but I just think it's an interesting topic. I really love getting into it.
Well, I think it's more relevant now with prices that have gone up over the last few years. People have these massive gains, and what do I do with it? And the thing with 1031s is that, the market we're seeing, and Jerry commented on this earlier in an earlier meeting, where we're seeing people coming down here because, they're not buying to flip, they're buying because they want to live. So if you get somebody who it's essentially going to be their home someday, and they're in their early 50s or something, they can do a reverse 1031, acquire the property, rent it for a couple of years, then turn it into a primary. There's a provision in the regulations that allow them to turn investment.
Let me show them kind of generally how that works. So normally you sell a property, you move the money into the new one. That's a traditional 1031. But in our scenario, we're actually going to buy the new one first.
Yeah.
So what we have to do is we have to reconfigure this. And so we have some sort of strange LLC that we formed that actually does the buying.
Yeah,
so
we don't actually do it.
So we buy it here, then you sell, and then you transfer the strange LLC to the actual buyer. And what it does is it puts it back in place where now the old technically happened before the new. That's essentially what we're doing. It's really interesting. I know it was something that first started with a taxpayer who was trying to make it work, trying to do this, and then it got codified in the Internal Revenue Code later. I think it's fascinating. I just love that scenario.
It was a taxpayer, his name was Starker. They used to call these Starker exchanges. And I think he escrowed the money for like 10 years before he replaced it. And the IRS lost the case when they went to tax court.
Yeah.
So to minimize their damages, they lobbied Congress for this code section that limited it to identifying the property in 45 days, closing in 6 months. That's way better than waiting 10 years. Having money sitting around for 10 years, which is what happened.
It's interesting, but I guess the key on this one is you don't need anything added to your contract if your buyer or seller are doing a 1031. You don't need anything for FIRPTA, need being the important word for FIRPTA. You don't need it. But talking about FIRPTA, there is one thing that might be helpful, and we've actually done articles on this previously, where it could benefit the seller if the buyer's going to be signing that FIRPTA affidavit. It's basically saying that the buyer intends to use the property the majority of the time personally. So if the buyer's willing to meet that standard and sign the affidavit, the seller's withholding goes from 15 down to 10%. And so that might be the one scenario where you would include some FIRPTA language. There's an addendum you can add for that as well. So that would be the only caveat, and that's this pro tip here, and a previous article that we wrote about in that scenario. Accepting backup offers. So in response to seeing more offers with contingencies, i.e. sale contingencies, many sellers want to continue showing the property in hopes of receiving backup offers. I've seen several contracts include language to allow this, but it's not necessary. Listing agents can continue to show the property to prospective buyers, even though it's under contract. So it sounds like, once you accept an offer, you shouldn't be allowed. A lot of people assume that you shouldn't be allowed to sell the property or, still show it. Jerry, have you dealt with that before where, just the listing agent, for whatever reason, thinks that once they've accepted an offer, they can't show it anymore? Is that a thing?
Well, it was. It hasn't been too much over the last couple of years because sellers didn't want to take any contingencies.
Yeah, that's a good point.
It was either close in 10 days or you're not going to get a deal. It was that simple. But what happens is that's an MLS rule.
Yes, it is.
I don't see any reason not to allow it through the MLS because you're disclosing it. I would
Exactly.
object if I was the buyer because I said, wait a minute, I gave you a deposit, I just signed the contract. Now you still want to continue to show it? I know there'd be time periods in it, and it's usually because I got to close on a house. And back to what we were talking about, I think your last session about, a contract where it's subject to the sale of a house.
Yeah.
It's got to be clearer than that. I've seen contracts where it says subject to the sale of property at such and such address. And then doesn't put a date. Doesn't put a date.
Yeah.
And sale isn't the same as close.
Yes.
Okay. He could already have a contract of sale, but it's not closed yet.
Right.
So there's some of the areas that I'm more worried about in a contract where an agent does something like that.
Absolutely. So you hit a couple of really good points. The first thing is MLS rules. So knowing the rule book is really important here. Nick Bobzien and I did a video on this a couple months ago, but basically, no matter what, once you sign a contract with a buyer, the listing agent is required by MLS to post the property as pending. And if there are contingencies, then I think one of the options is pending with contingencies. And that's how it is currently. In other parts of the country, it's done a little bit differently, but in our market, that's what we see. So
it's
even
called Clear Cooperation, I think, and it's from NAR, and we wrote an article on it in last August, and different games people play with it.
Yeah, and the games really are exactly that. They're not, it's trying to skirt the rule, but if you are a listing agent, you have to market pending either way. Within 3 days, you have to market pending, even if you put in some language that the seller is permitted to continue marketing the property or showing it. It's not really up to the buyer to allow a seller to do that. It's MLS rules. You're bound to that. So I've seen several contracts where they've added language like that, saying that the seller can continue marketing it. That's just not good enough. It doesn't do anything. So I would remove that. I don't want to see those if need be. And then separately, contingencies. Jerry, you hit a great point. They have to be specific. They have to be well written. Where there's a form, I think we should use it. But if there's not a form, then you really need to be leaning into an attorney to make sure that the addendum or other terms and conditions is written correctly, because it kind of needs the how, what, when, where, and everything in between in regards to writing up those contingencies.
Yeah, especially that clause, that type of change in the contract really bothers me because I can see nothing but pitfalls going through it. Subject to a closing on such and such date. Well, suppose it doesn't happen. Do you reference, does it go back to the closing paragraph of what happens if you don't make a date? That to me is too much practicing law in the hands of an agent. Yeah. And I would strongly advise them to make sure they get an attorney.
Oh, I completely agree. And if you guys want to look into more of what we talked about regarding sale contingencies, that video is available on YouTube. So it's youtube.com/Christian Ross. And we did that. That's the most recent video that posted. It's really an interesting topic. And really the main point of it is, if you can avoid doing a sale contingency, you probably should. And so we give you some strategies on how to avoid them entirely. Or if you're going to accept it, here's how you evaluate it. Here's how you modify that date to make it more friendly to both parties.
The other thing, Christian, is if I was the buyer and I'd object. I said, wait a minute, I'm giving you a deposit. We've agreed upon a price. Now you want to continue to show it and use my price?
But Jared, can you?
I'm sorry?
Can you object?
I object as a buyer.
You can try, right? Legally.
Yeah, well, I won't sign the contract. I mean,
so
unless I'm madly in love with the house.
Yeah, so let's do that scenario. Let's break it down a little further. Let's say you have a signed contract and you find out that the listing agent is still having showings. I actually had this call yesterday. We had an offer under contract at, let's say $1 million. And then we get another offer the next day for $2 million. And the seller's like, oh my gosh, we've got to take this one, right? A couple of things came of that. Number one, can the seller get out of the first contract? And will the other agents notice? It's a small community, and if they see them, coming to the property and doing showings and having an open house, there's no hiding all of that. And what will that do to someone's reputation in that community? That you accepted an offer and you're kind of you're kind of working against it behind the scenes. Yeah, it's very sticky, but contractually, it's the seller's house. And if they want to list it, they want to have showings and broker opens, I suppose they could do it. Absolutely. And there's, you could, and maybe that's why we see it in the contract where maybe the buyer made a low ball offer. The seller reluctantly agreed, but said, hey, look, I'll agree to your terms, but I want to be able to continue listing the property. And that kind of also gets into maybe a kick-out clause. Luckily, we don't see many kick-out clauses, but those essentially mean that if you do get another offer, the seller can come back to you, say, hey, waive all your contingencies, put down more deposit, otherwise you're out and I'm going to take this other buyer. So those kick-out clauses, those are even more unique, but we only see them if the buyer really made a lowball offer. Otherwise, no buyer would ever go for it, like you said, Jerry. A little messy, right? These are the type of deals you see when the markets start to kind of contract a little bit. The other thing we wanted to talk about that I'd rather not see where possible is insurance. So though we discussed adding insurance contingencies in a recent video, this may not need to be added if there's a financing contingency or if using an as-is contract. I think ultimately, I don't want to have an overly complex contract. If the more things that the buyer is requiring, that are deal breakers, the less likely we can get the deal done. So if you already have an as-is contract for 15-day inspection period, well, then why do I have to give you an additional contingency for insurance? Just do your work during the contingency period, during that inspection. Alternatively, if you already have a financing contingency, then you're already somewhat protected on the insurance stuff. That if you can't get insurance, you would be able to terminate under finance contingency, or if it's way above your budget and you get denied for the loan because of that, then you could get out for the financing contingency. So this one isn't like, hey, I never want to see it. This is more of those, don't overly complicate a deal because it'll backfire on you. It's a little bit more of that strategy. This one I think is interesting, which is the appraisal addendum. And this thing always kind of concerned me a little bit because I would see someone, let's say they're making an offer, has a financing contingency on it, and then they add the appraisal addendum on top of it. And I'm like, well, is that required? Do I need that in there? And the answer is no. If you already have a financing contingency, the appraisal contingency is not necessary unless something different is going on or you account for it differently. But generally, the appraisal addendum is for cash offers. Cash offers where the buyer still wants an appraisal.
I don't like the appraisal contingency.
Tell me. That's what I was going to ask. Tell me about the appraisal.
I don't like them because one, they're just incredibly inexact. I mean, I remember one transaction. It was a $2 million transaction, and we got two appraisals, and there was one was for $2 million, and the other one was 1.6. So you had a $400,000 difference. So telling people that this is not an exact science, that it's an art, as they teach the realtors in real estate school, is very difficult. And the second point is, if the buyer is making the deal subject to him getting a loan for, say, 50% of the purchase price, the financing contingency may not protect him. I mean, let's say it's $1 million deal and he's making it subject to him getting a $500,000 mortgage. He could get a $500,000 mortgage on an $800,000 property or a $700,000 property. So, you got to be careful. I don't like it. But I don't.
Well, I agree with you. So I'm not a fan of the appraisal contingency on cash deals because it's an extra cook in the kitchen. It's some third party that can come in and sabotage the deal. They can, it can put some doubt into the buyer's mind about whether they're overpaying or not. And the reality is, appraisals, like you said, they're inexact. They're more of an art than they are science. And it could flow, up or down $50,000 pretty easily based on comps and whether, what kind of valuation they put on a pool. So I agree. I think if you're doing a cash deal and the buyer is concerned about the price they're paying, appraisal contingency is not going to help. That's you're probably sabotaging your deal right from the start. And so I think you have to account for it elsewhere. And I said it here in this little blurb here. The buyer already has intimate knowledge of the property and the value the property brings to them. That value is more than just money, which is all the appraisal takes into account, as there may be emotional, physical, or other such factors at play. This could be the only house in the neighborhood with an elevator. This could be the one house that has that cute picket fence right at the front. And this was the one house you and your wife drove by every single day to get to your other house. It doesn't really matter if you're paying a little bit extra, according to what an appraiser might say. That's probably still the right deal for you for those reasons. The only reason you use the lender's appraiser is because the lender doesn't have that intimate knowledge and they need some sort of check. Yeah. It's like a double check on it.
One thing that helps sometimes, Christian, is standard R in the contract allows the buyer to get an appraiser in the property, even on a cash deal. You could have a cash contract. He may want to go out and get a loan for half the money. He can get an appraiser in there. Sometimes the sellers object, but it's right there in standard R. Yeah,
exactly. That's a good point. So if your buyer is making a cash offer but wants to get the mortgage, they don't need an appraisal addendum to still order an appraisal and have right to access the property. That's perfect. I love that. Jerry, what do you think?
Well, first of all, we have not seen a major shift in pricing yet, even though the market is somewhat slowed down. So, 2 or 3% here or there on a price, I don't think is a big deal. But if it went the wrong way, like back in the day of the recession, then we've got a problem. We're going to see more people that want an appraisal contingency. I've seen some banks in the past deny a loan because the seller says, look, the buyer says, I really changed my mind. My wife and I, we don't want to buy this anymore. And they use an appraisal as the reason they didn't get the mortgage. That's when, there could be an argument. Well, you still qualified, but the house didn't appraise. You didn't have an appraisal contingency. I could see where that might become an issue at a certain point in time. I'm hoping that we're not going to a major adjustment in pricing. And I don't see that happening because I don't see a lot of people that purchased in the last year or two putting their house on the market. They bought it for a different reason this time than just flipping it. They want to live in it. They want to stay here, whatever the case might be. And the rents are still very, very high in our market. So it's totally different than what we went through in the Great Recession. So, but I think in some cases there needs to be an appraisal contingency.
Point taken. Love it. All right. So those are things that I personally don't want to see in contracts. I'm sure there are others. It looks like I might have someone mentioned it in the FAR contract. You have to get appraisal during the inspection period if there is a financing contingency. No, you still have a financing contingency window. You still have that period where the appraisal is included in that. So if you get a loan denial because the appraisal didn't come in correctly, you can still counter, you can come back. You don't necessarily need that appraisal contingency added in on top of the financing contingency.
Well, they modified the financing contingency in FAR, to delete the appraisal requirement. It has to be dealt with in the front end of the process.
And during the inspection? Thank you. I love that.
Yeah.
All right. So here are things that I do want to see. And so I'll have to look at that. I appreciate you guys bringing that up. So things that I do want to see in the contract, and this is one we talked about last week in that sale contingency class, which is if you are contingent on another sale to get that loan, your financing contingency won't protect you if you didn't also have a sale contingency. So if you had a buyer that gets denied by their lender because they didn't sell their other house, but the deal was not subject to a sale contingency, then that's not a proper loan denial. And we've seen this a couple of times recently where the buyer is totally dumbfounded by that thought that, how did I get denied and not be able to take advantage of my financing contingency? It's because you can't get denied if you don't also have that contingency for that sale. It would be like an improper denial. To that same level, I had someone, Jerry, that they couldn't get it as a primary mortgage. It had to be a secondary home mortgage, and that was going to bump up their rate, cost them a little bit extra. And in that scenario, they tried to terminate under their financing contingency. And the argument, or the kind of the difficulty, was they were still approved, just not for a primary home mortgage. They could still be approved for a conventional second home mortgage, and it was just going to cost them more. So that was kind of a rude awakening to them. And the lesson learned was, if you need it to be contingent on the sale of your other home, it needs to be in there. If you need it to be contingent on getting a primary home conventional mortgage, that needs to be added in there as well. You ever seen anything like that, Jerry?
Yes, and when I haven't seen it is when it's usually a problem.
Yeah, good point.
Okay,
and that's why it's on this list.
Yeah, so everybody is usually worried about the term of the mortgage, the amount,
the interest rate,
the rate not to exceed such and such. They forget about some other intricacies. And I still believe you have to use the word subject to the sale and closing of the house at such and such address, because he's not going to be able to close if he doesn't get the cash out of that house.
Yeah, you want some definition around what is a sale, that it actually is synonymous with closing.
And I had, when I was on the media committee in Neighbor back in the day, they didn't remove pending contracts from the inventory level. And I took issue with it. It took them a year because they had to go through a cycle. I said, it's not for sale. Our rules say once it's under contract, you got to pend it. So why are we keeping that pending number in the current inventory level?
Why is it still being counted?
Yeah, it was being counted, and it was a significant number. So we were putting out to the public, we have more houses available for sale that we don't.
Yeah.
So,
wow. Interesting.
That's what happens when you're around for a while.
You've seen it all every which way. Yeah.
Not the good, the bad, and the ugly.
Well, speaking of ugly, perfect transition.
What?
Insurance. Speaking of insurance. So we've talked about this on several videos before. Insurance is a major issue right now. Costs are just skyrocketing, and it's changing significantly from the seller to the buyer. So I'll give you a couple of quick scenarios. The one I probably want to talk about most is, we have a new contract coming to closing, and there was some sort of damage claim on the hazard policy within the last 12 months. And everything was fixed. It was, let's say it was there was like a little bit of a water leak in the house, and it was fixed. Everything was dried out, new carpet, new drywall, baseboards. So the seller's mind, that's done. It was 10 months ago. It's behind us. We made a claim on our insurance policy, and now we want to sell. It's perfect, right? Well, the buyer comes in, they see a perfect house, and then a couple weeks into closing, into the contract, they get some insurance quotes, and the first insurance broker tells them, hey, there have been a couple of claims in the last couple of years, most notably the one 10 months ago. And because of that, you're getting denied from all these different insurance companies except for one. And that one insurance company is $20,000 for first year premium. And the buyer freaks out, understandably. Now, from the seller's perspective, this is not a big deal. It was a little water damage. We got it fixed and rectified. Yes, we made a claim, but it's all closed. It's done. But from the buyer's perspective, my insurance just went from $8,000 or $10,000 to $20,000 because there's only one insurance company that'll help me. And then they start picking at it. And they start saying, hey, I don't like it for this. And you didn't tell me that. And now, because it's costing them more. And it's just it's driving the train, as opposed to just kind of what other factors might be at play. So I think insurance is such a big thing, and it needs to be included on seller disclosures, any previous insurance claims, anything of note within the last 12 months, especially, anything that could cost insurance to go higher. And if you're a buyer, if you can get away with it, either do your insurance investigations before going under contract, or during an as-is closing period or investigation period, or have an insurance contingency included. In the event buyer cannot obtain insurance for less than $10,000 annually, buyer may terminate, something like that. And I can help you with that language if that were to come up. And specifically, I'm just kind of talking out of both sides of my mouth. In one sense, up at the top, I'm saying you don't have to worry about insurance, right? It's in a financing contingency. Well, it still may not be enough for a certain buyer. It might be too expensive. Even though they're qualified, they don't want to spend the 20. It could be that it was bad insurance. It could be that they have to take an exception to wind. They're not allowed to, they can't even get wind insurance, something like that. And for things like that, things that are specific that we can't really knock off ahead of time, the insurance contingency is a great solution. Still not seeing a lot of it out there, but I know it's an issue and it's coming up every week. And I just wish that, there was some solution that was easy and kind of fair for everybody. Jerry, have you heard anything about this? Any comments?
Just the price of insurance. They're now sending out their new invoices of getting close to September again, and it's every insurance company is trying to make up their losses for the claims they had to pay with Ian, and that's also with automobile insurance too.
Yeah, you told me about that. You were saying that because of some of the
cars floating down,
that got damaged.
Yeah, floating down the street in the water and going out in the bay and everything else. So it's not a good environment for insurance. But if you're getting a mortgage, I don't know when the bank or the mortgage company wants to know your insurance.
They really don't ask until the last week or two of closing.
That's what I'm saying. So it's really a requirement if there's a question and I'm the buyer, because if I want an out, think about this. We're 3-4 hours from the closing table and we don't have an okay on the insurance yet, and then we find out you're not going to get it. It could throw the purchaser's mortgage company not to qualify him.
Yeah. Well, and Bob has another point, Jerry, about polybutylene piping. So polybutylene piping is not a defective item on the contracts, but it does cause issues with insurance. And to that point, you also see some electric panels or water heaters, age of roof, these things that are kind of hot issues for these insurance companies. And you may not know about it until after you've done inspections, until after you've done a 4-point. So what I'm thinking is we probably need to do that up front. Have that information available, call insurance companies before you put your deposits down and start moving through that stuff. Or you just have an as-is contract where the buyer can do all their due diligence in the first 10 days and get those questions answered. That's always my solution in those. But yeah, polybutylene piping, that's a great example of where insurance is a problem.
The other thing, Christian, just real quick, is if I had the buyer, I would ask the listing agent, who is the insurance company insuring the house now? And call that agent.
Yeah.
And I'm going to know whether or not they want to reinsure it for the new buyer or not. And I'm going to know before we even get the offer accepted.
Absolutely. And I think that's something a listing agent should be aware of as well. So if you're going to be dealing with this one way or the other if it goes south. So if a listing agent wants to jump the gun, ask the seller, hey, who do you use for insurance? Would they be willing to talk to me? Let's see if we can get people pre-qualified on insurance. Hey, here's the guy. He's already agreed to insure. They just need to run a check on the buyer. Something like that.
Just a thought for the agents that are on this session today. Everybody thinks the work starts when you get a customer and you're showing them property and you're showing them property and you're showing them property, and then you finally get a contract signed. The real work starts once the contract's signed.
Yeah.
All the questions that have been talked about here, the issues that are talked about here, they're issues you have to deal with and know about.
Love it. I think that's smart. The other thing that we should probably add into contracts, and we're seeing this a lot, is the more people are using as-is contracts, the more I'm realizing that I've got to go back and we've got to teach them how to incorporate permitting and repairs back into the contract. So typical scenario, you have an as-is contract, you do your inspection report, and it comes back that, there's some open permits and there are a couple of repairs that need to be done. Those have to be added to an amendment or an addendum to the contract saying seller shall close permit number 884. Seller shall replace the dishwasher. And then you get everyone to sign it before the end of your inspection period. But quite a few times you'll get I'm seeing where we send the information on the open permit or an expired permit. We'll send it to the buyer. We'll send it to the buyer's agent. We'll say, hey, you probably should put this as an amendment. Otherwise, the seller's not going to be obligated to do anything about it. And it just goes and it's never addressed. It's never added. And the reason I think is that people assume based on FAR and NABOR standard contracts, permitting is just included. It just gets done behind the scenes. The only thing to remember on as-is contracts is you have to manually add them back in. So seller shall close permit PRD 2023-8843. That's a good permit, right? So I think I've seen that on $10 million deals. I've seen that on $300,000 deals. And it's just one of those things where you have to realize if you're going to start using an as-is contract, you'll have to add those things in manually.
You also have to watch out for financing contingencies if you have a repair addendum to your contract, because someone just got upset over roof repairs.
Absolutely. So if you're not used to working with a lot of lenders, you have to realize that when you start putting in things that seller will give $1,800 in lieu of inspection repairs, that's not going to work. Lender's going to see that and they're going to kick it out and they're say we don't want to see anything about repairs. It's kind of a silly mentality. I hate it when the lenders are like, no, don't show me that. It's like, how does that really help you? That's ridiculous, but that's what they do. They all do that. So before you decide on how to make a credit or what you would do with it, call us, lean into us, and we'll help you kind of navigate that. But typically what I see is 2 lines. Seller shall give buyer $1,800 as closing cost credit. And then the second line, buyer hereby waives its inspection period, or something along those lines. So it's like buyer can't double dip, but we're still protecting the buyer in terms of that money being shared. Letter D here, HOA and condo disclosures. I'm still seeing a couple of FAR contracts where they don't use rider A or rider B. Additionally, I don't see enough of the NABOR HOA disclosure addendums being included. So just a good reminder that needs to be in there, and because otherwise a buyer could terminate. And it's also not fair to a buyer because they don't know their fees. And then this one, letter E, assignments. So NABOR automatically allows a buyer to assign, not be relieved from liability, but it's automatic. So if you're using a NABOR contract, nothing you need to do, so you're okay. But on a FAR, you have to check the correct box, because going back up to 1099 or 1031 exchanges, you're going to want to be able to assign it unilaterally. And then optional. This kind of summarize everything for us. Assessments ? So Jerry, we talked about insurance premiums going up. But what else is going up is insurance premiums for the condo association, the master. So, how is that affected? What we've been focused on to date is whether there are any special assessments coming down the pipeline. Buyers always want to know about that. It's kind of a hot topic. But when insurance for the condo master goes up, buyers get really flustered by that too. And so I think we got to kind of be proactive about it. It's not necessarily contractually required, but if you disclose that, within the last 30 days, the board agreed to double the annual assessments, the dues, I think that needs to be disclosed. That is an absolute, even if they're just talking about it, just to protect the seller from, backlash and things of that nature, get out in front of it. We're seeing it so much now where buyers are just getting sideways because insurance is a lot more than they expected and the assessments are a lot more, and there might be a special assessment and they only knew about one of those things before they went under contract. It kind of spoils the whole deal, and it makes everything so much harder. So it's optional, but I would love to see more people doing it because playing damage control behind the scenes is been really hard. And to that point, disclosures. So seller disclosures are not required by law, but they do protect the seller. So I want this to be disclosed. Jerry, hypothetically, if there was a property that had $20,000 in mold remediation, I think you should update a seller disclosure. Wouldn't you say that would be a smart idea?
It would be a very smart
It'd be
idea.
a smart idea. Maybe even disclose that there was an insurance claim that was made and closed out. Something like that. I think that'd be pretty smart before going and trying to sell the property to the next buyer.
What I think might even be smarter is if you were able to put a list of the things that you think a listing agent should have a discussion with the seller before it even goes on the market.
I think that's great. I'll happily do that.
Yeah, I mean, you've got a venue of people now, and I think it would really be helpful. And it could always be modified if something new comes on. Now we've got this disclosure for foreign buyers. I mean,
I love it. So let's see, number one, seller disclosure, and then talk about it. Ask follow-up questions. Hey, what you put this here, but didn't you say that you pulled a permit for this, or didn't you replace the water heater? You didn't disclose anything about it. Oh yeah, I forgot. So go through
and
it.
the seller's going to know. I mean, most associations bill quarterly, so they're going to know what the numbers are. And the guys that run the condo and the homeowners association aren't the friendliest people to get information out of.
Oh, they're pretty brutal. Yeah, it can be really tough. So the other thing would be condo association documents. That could be done before you list the property. Pull them all together, have them available. Anyone that comes to see the property, get their email, send the agent the copy of the forms. Get it out there. Put it out. And I do see a lot of people put it on MLS. I think that makes a lot of sense. But some people are not willing to do that. But that's work you can do ahead of time. Condo association docs. We always talk about looking at the vesting deed. So a vesting deed is the deed where the seller took title. So it vested in the seller. That's why we call it the vesting deed. So I think we should download it. Pull up the vesting deed, download it, see how they took title. Is it in their trust, an LLC? Is it in their name personally? If one of the parties has passed away, how are they holding title? Call us. We'll go through it with you. But I think this is like a really good initial step. You can inventory furniture. I didn't spell furniture right. I think having a list of the furniture that the seller agrees to convey or will be conveying is really smart. Even if the seller's not ready for it, just go around and take pictures, make notes, put a list together. It's part of the process. You got to understand your client.
And again, if you have a mortgage involved, you might want to have the furniture handled separately.
Yeah, if the buyer's getting a mortgage, we have to handle that separately. Not all furniture is $1. Not all furniture is $0. So if you allocate $10,000 towards the furniture, that's great. Just reduce the purchase price by the 10 and have it be two separate deals. We do have personal property agreements that we can share with anyone that wants to use it. That's kind of right off the top of my head. I'm sure I'll think about a couple more, Jerry. I appreciate that. We had a couple questions and then we'll close up. How do sellers disclose future assessments for condo 3 stories and up plus 30 years old for the milestone inspections? Help. Okay, so what they're talking about is the new Florida statute regarding certain condos that are 3 stories or more and within the, I think, mile or 2 of the coastline. And they require those condo associations to do milestone inspections. I think it's every 10 years they have to do an inspection for the foundation and other things. And what they're trying to do is to ensure that property managers and the boards are actively fixing and repairing and maintaining properties that are otherwise being ignored, or that the maintenance is being deferred. So there's nothing in the current contracts that talks about these. They have not yet updated the condo disclosures. It's not one of the additional forms that has to be shared to buyers. But I would say if there's something that the board has released about the milestone inspections within the last 12 months, then I think it should be shared. It's pretty straightforward to take maybe an email or a summary or the last meeting minutes where they talk about it and provide that to the buyer in advance. But currently, those condo document requirements, it's not included. So there's nothing you have to do legally, but it's another one of those things that could.
Christian, in the recent case we looked at, the one where they had the flooding, and it was several years ago, what those people got sued for were negligent disclosure and also under the late material defects of Johnson v. Davis. So if it's something on this new statute, it's probably a big number. And I think it would be easier to argue under Johnson v. Davis that this is a latent material defect that should be disclosed, or alternatively, like we had in that Lober decision, that the seller is negligent in their disclosure by not pointing this out.
Yeah, and it also depends what contract you're using. So in FAR it talks about pending special assessments that have been discussed in recent meeting minutes.
The last 12 months.
12 months. So you might have a buyer who's already protected under the contract, but NABOR doesn't have that. NABOR only talks about the assessments, special assessments that have been voted on and approved and allocated. All right, we have another question. Reserves are a big issue with the condo and HOA associations. Be sure you're providing the most recent financials for any association. Yeah, so that's actually interesting. Condos and HOAs, they're not the same. And the requirements, they come from different statutes. So if we look at the condo statute, it requires that the seller provide the most recent copy of the financials. You might see budget, P&L, reserves, whatever it may be, but they're required by law to give the most recent financials. Right. HOA associations, that statute doesn't technically have that requirement.
Nope. So
what this person is referencing is, hey, I found that it's still really valuable to give those financials to a buyer, even if it's in an HOA. And I think that's great, especially if there's like some meat on that, on the bone there. If there's something like a major capital improvement that they're doing at the clubhouse, some major infrastructure improvement that's going to cost, they borrow $5 million to do it. I think that's relevant enough to disclose. We have a current lawsuit where there was they're in depositions at the moment, and the buyer was really upset because they found out that the golf course was being completely gutted. And so they weren't going to use it for the next 3 years. And so they terminated, and they're suing for their deposit. And they're kind of coming to that same issue of, was this something the seller had to disclose, or is it something the buyer could have discovered on their own? It certainly wasn't statutorily required that they disclose it, but was it some sort of negligent disclosure? Something else. That'll be really interesting. So, we are seeing, and I think this is something that I had to see it to believe it, but buyers are way more anxious because they're paying that high price, they're paying high interest rates, there's not a lot of inventory, so the pickings are slim. And so they tend to hyper focus on every little issue. So if you can get out in front of it, it's going to benefit you. If you can be all out in the open, you'll sleep well at night knowing that it's all out there. You have nothing to worry about. You just closed it and the buyer came anyways. That's what I would love to see. And I'm pushing our clients to do that more and more and more because, Jerry, I'm getting tired of trying to fix it after the fact.
Let me just say, and it's going to stay this way for a while. We're not going to see robust inventory come back on the market. The builders have already said they're not going forward with full blast. So there's always going to be a stress. And I think the more the seller is prepared with questions that are going to have to be answered better sooner rather than later, I think the more smoother the transactions will be going forward.
Yeah. It's hard not to look at what your neighbor is doing and what they got, and not look at what you're going to get instead. But really, you have to do what's right. You gotta be out there. You gotta be open. If you need something, if it's a deal breaker, it has to be in your contract. But if it's not, maybe there's some other way to get what you're wanting. And like I've said, I love the as-is contracts in lieu of some of these other contingencies. And if you are using a contingency, I want you guys to understand it. I want you to ask a lot of questions and kind of just push us. Let us help, lean on your coworkers and lean on your brokers as well. Jerry, thank you so much. I appreciate it, Dad. Thank you. And everybody, good luck. If you need anything, don't hesitate to call.
All
Thank you,
right.
Chris.